Article 22, Respect for Privacy. This article begins with one comment highlighted in a panel. I cannot access anything I would like to access without support from another person. Hui participant. Introduction. This article notes that a person must not interfere in another person's private affairs, whether they have disabilities or not. People who hold information about others, such as their health status, should keep this information private. General comment. Disabled people are often required to interact with a number of agencies, government and non-government, to receive support, and so privacy of information and rules around how information is shared are important to protect the rights of individuals. Importance of Article 22 to disabled people in New Zealand. Disabled people have the right to have their information kept private, in particular their health and disability information. Current place of Article 22 in New Zealand law and practice. In New Zealand, an individual's rights of access to their own personal information is governed by the Privacy Act 1993. The Privacy Commissioner has the power, under this Act, to issue codes of practice that set rules on how different kinds of information, including health information, must be treated, and to investigate breaches of these rules. Committee's previous dialogue with the state on Article 22. In the government's first report to the Disability Committee, it outlined general rights under the Privacy Act and specific rights relating to health information. It also mentioned a review undertaken by the Law Commission, leading to the government of the time considering using technology to share health information. Comment on the realisation of Article 22 in New Zealand. Concerns about privacy for disabled people fall into four main categories: organisations and individuals' failure to maintain appropriate standards of privacy, difficulties experienced in exercising privacy rights, the need to involve third parties in private matters due to inaccessibility of information, and repeated requests for proof of eligibility. Under the Privacy Act, agencies must follow rules when dealing with personal information. In reality, many disabled people report frequent breaches of their privacy. The IMM is aware of anecdotal instances of service providers sharing information about disabled people without permission. A home care coordinator notified the client's babysitter, who answered the home phone, of changes to support worker schedule. Taxi drivers discuss the other disabled people they have taken on trips in the past week, and staff gossip about clients in the canteen area. These breaches, while not always of a serious or personal nature, create a sense that the lives of disabled people are scrutinized and public in a way that the lives of others are not. During consultation Hui and survey to inform this report, some disabled people also reported concerns that their private information is passed on to third-party organisations without their permission when their services are outsourced from their main service provider to other contractors. People with mental health diagnoses report that the inappropriate sharing of sensitive information leads to them feeling stigmatized and being discriminated against by service providers, in particular non-health agencies. Disabled people have been affected by the Ministry of Social Development's investigations into the private affairs of beneficiaries, a practice found by the Privacy Commissioner to have breached the Privacy Act. End note 175. When privacy rights are breached, disabled people report challenges with having their complaints heard and resolved. Service providers are reportedly often unwilling to resolve matters, and complainants are sent to the Health and Disability Commissioner's office or the Privacy Commissioner, requiring them to further disclose personal information in order to have their complaint heard. Some disabled people report that when attempting to exercise their rights to access information held about them, as guaranteed under the Privacy Act, the information is provided to them in inaccessible formats. While some progress has been made in enabling disabled people to provide and access their information in accessible formats, overall progress in this area is slow. The majority of application forms for support services or financial assistance and information received from government and other agencies are inaccessible to many disabled users. This means involving a third party when communicating with government departments and other agencies. Many disabled people, when using technology, would prefer to be able to complete forms online using accessible websites and receive information by accessible email rather than, for example, asking a family member to read their medical test results. Disabled people reported that they are often required to provide repeated copies of medical verification to prove their eligibility for supports. This means that their private disability information is accessed by more people than might be necessary and increases the risk of privacy breaches. The Social Investment Agency, SIA, is working on the data protection and use policy to support New Zealanders to navigate the social sector more easily. It would also help those working in the sector to work collaboratively to improve services for all New Zealanders. End note 176. Disabled people have been involved in the consultation process, and once implemented, it is hoped this will work to reduce some of the barriers disabled people face when trying to access services and information. Recommendations. The IMM recommends that the government 67. Conduct an audit and/or situational analysis of disabled people's experiences with privacy and information sharing. 68. Instruct all public sector agencies to ensure that any personal information they gather or hold about disabled people is secure, accessible, and constitutes the least amount of intrusion necessary. 69. Ensure public sector agencies and service providers understand their responsibilities under the Privacy Act 1993 and the Health Information Privacy Code, and be required to demonstrate they have robust training and privacy policies in place in order to receive government funding, particularly in cases where services are outsourced to third parties. This should include improved complaints procedures and assurances that information provided to complainants will be sent in accessible formats. 70. Instruct public sector agencies to provide all official documents in accessible formats, with the option to complete them online using New Zealand Sign Language or with the assistance of appropriately trained staff. 71. Ensure that the amount of medical data that disabled people are required to provide in order to access services and supports is reviewed and reconciled with a view to reducing repetition, only obtaining necessary information, and ensuring secure data sharing mechanisms are in place.